Hi, I'm attorney Casey Walker. I want to discuss the top 10 things you need to know about VA examinations. Let's start with what is a C&P examination. A C&P examination is used by the Department of Veteran Affairs to determine whether you're eligible for a service-connected disability and to determine the degree of that impairment. Additionally, a C&P examination might be scheduled to determine whether your symptoms have maintained, gotten better, or gotten worse. That's called a future examination. Keep in mind, when you go to a C&P examination, the only exams that are going to be scheduled are the exams that the VA employee requests an examiner to do. So when you go to an examination, don't get upset if they're not doing the exam that you thought you were going to be examined for. That's because the VA employee didn't request the examiner to do that examination. And you might have a different examination in a week or two or a month or months down the road. So be gentle with the examiner on that front. Number two, let's talk about what is the difference between a medical opinion and an examination. Now, this is a critical, nuanced thing that you want to be aware of. A medical opinion. Now, what happens is when you go to this examination, you don't realize it, but two things are usually happening. One is they're trying to determine whether you have a condition that's attributable to the military service. And then two is they're trying to determine the degree of your impairment. Veterans fail to realize that where they're already service-connected with a condition, they don't need to go in and prove causation and that their condition was caused by the military. You are already granted service connection for that condition. So when a medical opinion is requested, you're trying to establish service connection. That's when you want to be concerned with causation, that you're certain that your military activities cause whatever condition you might have today. Compare and contrast that to a medical examination or a disability DBQ report, which both these things are usually happen at the same moment, but there usually are two things happening at the same time, and they're critically nuanced and different. So an examination is going to be looking at the severity of your impairment. Again, this is different than determining whether you have something linked to the military, which is a medical professional opinion, where they review all the records and they say, yeah, I see this happen on active duty, or I see these environmental exposures and I see what they have today. It's as likely as not that condition A was caused by their military service. That's a medical opinion. Medical examination is going to be determining the degree of disability for whatever condition it might be. So make sure you understand that nuanced condition. So the VA compensates these disabilities on 10% increments using what's called VA math. You can see one of our other videos on our website, which is found in the description below, to see that type of VA math, which is a topic for another day. But when they break these 10% increments down, they are paid accordingly to whatever percentage and how many kids you have and how many dependents you have and if you're married. And as you can see on the screen here, you have 10 and 20%. 30% disability is where the dependency rates kick in. And there's a litany of different variables that dictate what your payment's going to be. So you can play around with that. The website's in the description. So the third thing we want to discuss is what is the standard of evidence to obtain service connection. There's something known as the reasonable doubt doctrine. The reasonable doubt doctrine is an approximate balance of positive and negative evidence which does not satisfactorily prove or disprove the claim. So what does that mean? Well, if you're familiar with gambling, you know, the house always wins, the house always wins, the house always has the edge. If you have an equal balance of negative or unfavorable evidence and favorable evidence, it pushes to the veteran, which is it's incredible. It's very favorable to the veteran. The system is intentionally favorable to veterans and claimants. So the reasonable doubt doctrine is to say that where it's as likely as not that a condition is caused by military service, that condition must be service-connected, where there's a relative equipoise of evidence on balance. This actual standard is found in the regulation at 38 CFR 3.102, and there you can read the reasonable doubt doctrine for yourself. This link is found in our description. The fourth thing you need to know is who's going to be doing these examinations. Well, it depends. That's always a magic answer, it depends. But where you have general medical conditions, those are going to be a nurse practitioner, a physician assistant, an MD, or a DO. So, you know, the whole alphabet of acronyms, as long as it's someone with a licensure and a medical professional. But nurse practitioners and physician assistants tend to be the most common people you will see. Now, a lot of veterans try to seek medical doctors and DOs for their evidence. So it's not necessary to seek statuses and labels of medical professionals. A nurse practitioner and a physician assistant, their opinions are going to be equally weighed to a certain extent as an MD's or a DO's. What's more important than their titles is the logic and reasoning they use to support their opinions and their determinations. So keep that in mind. So when you go into the VA examiner and it's a physician assistant, that's okay. This is status quo in the VA system. When you seek an eye exam, maybe you have some type of double vision or you have some strange eye condition. That'll be an optometrist usually. On a rare occasion, an ophthalmologist might be pulled in, but it's usually an optometrist. When you have an audiological condition like hearing loss or tinnitus, that's usually an audiologist. When you have a dental condition, that'll be a dentist. When you have a mental health condition, PTSD, depression, anxiety, that will be a psychologist. On a rare occasion, the VA will utilize a psychiatrist. And bear in mind with that social workers, while their opinions are probative and helpful, that a psychologist and a psychiatrist for mental health carry much more weight than a social worker for VA disability compensation purposes. I'm just a messenger. I don't necessarily agree with that at times, but that's the game we got to play, so make sure you're aware of that. A TBI, a traumatic brain injury that is, those are more nuanced. So that has to be a psychiatrist or a neurologist or someone who has taken the VA's traumatic brain injury training and qualified and passed that course. So those are all the medical professionals who will be doing the examinations. And just it really depends on the claim that you're making. So if, respective to the type of claim and that condition will be the respective doctor. The next thing we're going to discuss is pyramiding restrictions. What is pyramiding? A lot of veterans aren't aware of this, but the VA has rules that don't allow the same symptoms to be compensated twice. And this just makes sense. You shouldn't receive double compensation for two diagnoses that both manifest with the exact same symptoms. For example, mental health. You can only receive compensation for one mental health condition. Another example would be respiratory ailments, such as if you have sleep apnea and you're service connected with sleep apnea at 50%, but then you want to get your asthma. You want to get asthma service connected, and you finally get it service connected, and you spend 6 years fighting it, and the pyramiding laws don't allow you to receive compensation for both sleep apnea and asthma. So usually what happens is sleep apnea compensates more significantly, and so they give us 0% for the asthma. But the important thing is that you're aware that the same symptoms can't be compensated twice. And again, this is found in anti-pyramiding regulations. Let's take a look at that regulation. So 38 CFR 4.14 is the specific regulation on point, which discusses avoidance of pyramiding. You'll find that link in the description. You can read it for yourself. But specifically, it states the evaluations of the same disabilities under various diagnoses is to be avoided. And then it gives a little bit more legalese, but the gist of it is, again, you cannot compensate the same symptoms more than once. So let's move on to the sixth thing you need to know about C&P examinations. Understanding the rating criteria. So we're looking at DBQs, disability benefit questionnaires, the examination reports. What is the rating criteria? How do you know what's important? Well, we got to dig into something known as the schedule of ratings, commonly referred to as the rating schedule. So let's take a look at that briefly. But what you need to know before we look at that is almost every condition under the sun has very specific symptoms associated with it in the regulations. And as long as you meet that criteria and you have those symptoms demonstrated, then usually, generally, you'll receive that percentage associated with those symptoms. So that's how the rating schedule goes. Keep in mind that the rating schedule does not include all conditions. Where a veteran has a condition that's not found in the rating schedule, in such an instance, you have to look at the analogous rating law. And what that is an adjudicator or a judge is given the discretion to award service connection for a legitimate medical condition that's not found in the rating schedule. What they have to do is they have to find a similar condition, something with similar symptoms. So, for example, historically, where someone has gastroesophageal reflux disorder, that's not found in the VA's rating schedule and the regulations. So they rate it analogous to hiatal hernia under diagnostic code 7346 because the symptoms are so similar and because they don't have a condition for GERD. But the important thing when you're looking at analogous ratings or the VA's rating schedule is the symptoms, not the diagnosis, but the symptoms. The VA compensates symptoms, loss of earning capacity, symptoms. So let's take a look at the analogous rating regulations and let's take a look at the rating schedule very quickly. And you'll find these links in the description. You can further explore them yourself. So when taking a look at 38 CFR subpart B, this is going to be where you find the rating schedule criteria. Now you'll notice at 4.71A, it says schedule of ratings, and that's for joints. Anywhere where you see schedule of ratings, similarly, you'll see schedule of ratings I under 4.79. Similarly, you'll see schedule of ratings other sense organs under 4.87a. And it goes on, but these are the ratings for the respective bodily functions. Let's take a look at the analogous rating under 38 CFR 4.20. This is where you're going to find what an adjudicator or judge is required to do when they do not have a condition found within that rating schedule that we just looked at. Under that regulation, it states when an unlisted condition is encountered, it will be permissible to rate under a closely related disease or injury, in which not only the functions affected, but the anatomical localization and symptomology are closely analogous. So really that's a mouthful, and it keeps going, but it's just saying similar symptoms. So that's really the big picture of what you're looking at when you're trying to understand rating criteria. Adjudicators and judges are told exactly what and how they're supposed to rate certain medical conditions, and it's found in the VA's rating schedule. Where you don't have a condition, it has to be rated analogous to a condition that does exist. Let's talk about the seventh thing you need to consider: events and injuries before and after active duty. So a lot of the veterans that we represent, and I hear this all the time, is they go in and they go to the examination and they tell the examiners about just terrible things that happened growing up. Let's say it's a mental health examination. And they'll go in talking about how their dog Fido died when they were 7, and their dog T-Rex died when they were 10, and their life was so traumatic before they went in the military. And then the examiner naturally writes up a report saying that their PTSD was caused by Fido and T-Rex passing away. Don't do that. Don't do that. I'm not saying to lie. Do not lie. But at the same time, don't lift up things before the military. You want to give the examiner a reason to associate your medical condition with something that happened on active duty, not Fido dying before the military. Similarly, let's say you're a kid and you like to stare at the sun for countless hours as a child, and now you have some type of ocular condition. Don't go in telling the examiner that. I mean, don't lie. If they ask you if you stared at the sun for hours as a kid, the answer would be yes. But you want the causation to be attributable to something on active duty. Don't lend too much information. Another example would be maybe you were a punk rock singer before you went into the military and you were on a lot of loud music. And then you join the military and you're around a lot of guns and you're around a lot of loud aircraft and naval vessels, just extreme noise exposure in the military. But if you tell them about being a punk rock singer, maybe that audiologist will associate your hearing loss and tinnitus with your punk rock days. Common sense. Lift up and elevate the things that happen on active duty so that you can try to get that service connection. So next, let's talk about context and relevance. This one can make me smile at times because veterans will go in talking about things that just really aren't relevant. If you're already service connected with a condition, you don't need to convince the examiner that your condition was caused by the military. That ship sailed. It's been conceded by the VA. So focus on the symptoms when you're in that situation. But conversely, if you're not service connected yet, the examiner, let's say you have a terminal leukemia, the examiner is not going to be questioning whether you have a severe medical condition. Every reasonable medical professional under the sun would agree, if you're terminally ill with leukemia, that you're very ill and you're severely incapacitated. No one's disagreeing there. The focus instead needs to be, was it attributable and is it causally related to your military service? So context, know why you're going into an exam, so that you can present evidence and plan accordingly. Limitation of motion, pain with joints, hospitalizations, surgeries, employability limitations, and different types of unique therapeutical treatments can all be probative and helpful that you want to communicate during your exam. But if you go in for a leukemia examination, they don't need to know about your hemorrhoids. So again, context and relevance. Make sure you're talking about relevant things so the examiner gets an appraisal and a picture of what your symptoms really are. The ninth thing we're going to discuss is the documentation you want to prepare before you go to the exam. This is singly probably the most important thing we're going to discuss here. Write a statement out. Make it 2 pages, make it 3 pages. The more the better, and the more detailed the better. But articulate your symptoms that you're having with whatever your condition is. Keep a contemporaneous diary or journal. Write those symptoms out. Explain to the VA the symptoms that you're having. Those symptoms should parallel the rating criteria. If you go to the description, you'll find free symptom logs found on our website within the resource tab. And then treatment. If you have a condition, don't show up at the examination on the day of the exam hoping that an examiner is just going to assume everything you tell them is correct. You're not a medical professional. And if you are a medical professional, you still need to get the medical evidence by being treated. Don't go into your examination complaining about nerve problems if you've never reported it previously. If you have a history of nerve problems, they should probably schedule you with what's called an EMG, or do some type of modality testing to confirm that you do in fact have some type of nerve problem associated with an underlying etiology or an organic nerve disorder. But don't go in there just hoping they'll make that diagnosis for the first time and that your first complaint in history is with the examiner. That's not fair to the examiner. You gotta throw them a bone. You gotta give them something to work with. Don't go in complaining about acid reflux unless you have a history of seeking omeprazole or different treatments for your acid reflux. You get the idea. You have to give them something to work with. It's not fair to the examiner. Once you've developed and you've actually created some of this evidence with your sworn statements and your symptom logs, print it. Bring it in, physical copy, and hand it to the examiner. They might say, I don't want it. If they don't take it, send the VA notification that you tried giving the examiner this evidence, send it to the VA with a cover page saying, I tried to give this to the examiner, but they refused to take it. But build your case before you show up for the examination. This is really important. This is singly the most important thing you can do to help your case and to prepare for the C&P exam. It's not what you say at the examination. It's what you do before and the evidence you develop before you get there. This is important. Be credible. What do I mean by be credible? Well, if you say you need a cane to ambulate, you should probably bring the cane in with you. If you say that you have severe instability of your knees, you should probably have a knee brace on at the examination. If you say that you struggle to walk without your foot orthotics, you should probably have your foot orthotics on. If you say that you can't get in and out of your seat because your back and hip and knees are so bad, then you should probably look like you struggle to get in and out of your seat when you sit down for the examination. Be honest and be credible. And if you tell someone that you can't remember who the current president's name is, it probably won't jive with the examiner if you're a nuclear engineer or something, because that just doesn't make sense. So be credible and use common sense. And again, back to piggyback what I said earlier, be kind. Examiners are human. That golden rule is common sense 101. If you're nice to someone, they're more likely to want to reciprocate in some way. So those are the top 10 things I think you need to be aware of when contemplating C&P examinations. Check out the descriptions for the websites that we discussed. And if you like this video, subscribe to our channel. Have a great day.